Good afternoon. The subcommittee meets today to receive testimony on the epidemic of sexual assault in the military and the failure of military leadership to address it. Despite 30 years of promises to change and over $1 billion spent on prevention and response measures. Since this is the first subcommittee hearing of the year, I want to start by welcoming Ranking Member Tillis. I look forward to continuing the great relationship we've had over the past 6 years and our work to provide our service members, their families, and the department's civilian workforce the tools, support, and the resources that they need to do their jobs. Today, we will hear from survivors and from survivor advocates on their experiences with the military justice system, from the Government Accountability Office on the many changes in laws regarding sexual assault in the military, and from outside experts on the effects or lack thereof those changes have had on reducing sexual assault within its ranks. The first panel of witnesses include Ms. Natalie Quam, the founder and president of Whistleblower Law Firm, Ms. Amy Braley-Frank, the founder of Never Alone, Ms. Amy Marsh, a survivor of sexual assault and advocate, and Mr. Quentin McNair, a survivor advocate who retired from the Army after 24 years of service as a senior drill sergeant and sexual assault response coordinator. The second panel will have Ms. Brenda Farrell, Director, DoD, Strategic Human Capital Management, Government Accountability Office. And the third panel will have Mr. Eugene Fidel, Senior Research Scholar at Yale Law School and Adjunct Professor of Law at New York University Law School, retired Colonel Don Christensen, United States Air Force and President of Protect Our Defenders, and retired Colonel Lawrence J. Morris, United States Army Chief of Staff and Counselor to the President, Catholic University of America. The subcommittee will also receive statements from other survivors and survivor advocates who, unfortunately, given the time and space constraints of this hearing, weren't able to be accommodated. Without objection, we will include all of their statements in the record. There's an epidemic of sexual assault in the military. The DoD's most recent survey estimated that almost 21,000 service members were sexually assaulted in 2018. That makes them more likely to be raped by their fellow service members than shot by the enemy in war. Since 2013, unrestricted reports of sexual assault in the military have doubled, yet the rate of prosecution and conviction has halved. The assailant was often someone in the survivor's chain of command, the same chain of command responsible for deciding the case. These commanders are not lawyers. They are not delivering justice, and they are not doing enough to help survivors. 2 in 3 survivors who report the crime experience retaliation or ostracism, like Amy Marsh, who you will hear from today. Last month, following the tragic death of Specialist Vanessa Guillen, the Fort Hood Independent Review reported that the command climates surrounding sexual assault response and prevention programs were so ineffective that the world's largest Army base was, quote, a permissive environment for sexual assault and sexual harassment. We must do better for the people who sacrifice so much for our country. I first introduced the Military Justice Improvement Act in 2013 with the goal of professionalizing the way the military prosecutes rape, sexual misconduct, and other complex crimes. Every year since, military leadership has come before us and said that the chain of command would solve this problem. They're not solving the problem. They have failed. The statistics on sexual assault that the DoD has been reporting since 2006 make it plain. There has been no progress made over the past 15 years. We have given the military enough time and enough resources to fix this problem. Congress has given the military more than $1 billion $500 million in fiscal year 2019 alone, enacted 249 legislative provisions, and chartered special panels, commissions, and advisory committees to address this problem. Not one of these steps has reduced sexual assault within the ranks. We are right where we were when we started. Nothing has changed. Nearly every Secretary of Defense since Dick Cheney has promised this country and the service members who serve us zero tolerance for sexual assault. Every general or commander that has come in front of this body for the past 10 years has told us, we've got this, ma'am, we've got this. Well, the truth is they don't have it. The military justice system simply is in the wrong hands. The Military Justice Improvement Act would put these serious criminal cases in the hands of senior, experienced military prosecutors. It would eliminate command bias and create a fair, impartial system. It is our duty to our service members to solve this problem. I invite my colleagues to recognize the lack of progress made over the past 10 years and to support our effort to rethink this system and professionalize the way the military handles these cases. I would look forward to working with you, Senator Tillis, to finally take the necessary steps to address this scourge on our military. Senator Tillis.
Thank you, Chairwoman Gillibrand, and to I was going to call you Coach, but I guess I should call you Senator Tuberville. Welcome to the subcommittee. Senator Gillibrand, I want to thank you for holding the hearing, and I truly admire your unwavering dedication to addressing sexual assault. I agree with you that sexual assault has no place in the military, but I believe we can't just stop there. It has no place in our society. While today's hearing is about focusing on our military, it's important to remember that this is not just a Department of Defense problem. If it's an epidemic in the Department of Defense, then it's even more so in our society. If we're to have any hope of fixing the issue for our military, we need to tackle this issue more broadly. Each year, about 180,000 young Americans enlist for active duty service in the armed forces. Statistics show that sexual assaults are most prevalent among our youngest service members, those who are newest to the military, generally ages 18 to 24. In comparison to similarly aged college and non-college students, the rate of sexual assault is lower in the military. The rate of reporting a sexual assault is higher in the military, and the rate of sexual assault prosecutions is higher. In fact, colleges and universities, I was at a gathering in Annapolis a year or so ago, are coming to the Department of Defense and asking, help us, show us how we can start fixing this problem. Now, preliminary data from the GAO study due later this year shows that between 2004 and 2019, Congress has enacted 249 legislative proposals concerning sexual assault in the military. But the reality is, only about 9% of them have anything to do with prevention. So I hope as we move forward this process that we spend more time on the subject of prevention. Senator Gillibrand, I'd ask unanimous consent that my full statement be put into the record. But you and I had a great conversation about 2 weeks ago. And I've also had conversation with current service line secretaries. And I've been here for going on 6.5 years. I've spoken to those service secretaries and commanders under the Obama administration as you were making proposals. That's what I'm saying. You're after it. You're staying after it, and I admire you for it. They expressed concerns. Under the Trump administration, they expressed concerns with removing it from the command. And more recently, under the Biden administration, they've expressed concerns. I told the service secretaries in the most recent conversations about a month ago that you need to come with a credible proposal because in the wake of the Fort Hood incidents, there are members that are beginning to wonder whether or not we should keep the current structure. Senator Gillibrand, you and I didn't get to have an opportunity to talk about the data. I'm a data person, and I'm trying to figure out, it seems like sometimes in our hearings, we hear different views on different sets of data. I think one of the things that we have to do, when I hear that the conviction rate is lower, I hear that. On the other hand, I hear DAC and IPAD say that the number of prosecutions are higher, the conviction rate's lower. So it seems like under the current structure, one argument against moving it from the command is that more go to court-martial than the DAC IPAD would expect. And if you've got more going through prosecution, then you would naturally expect that maybe the conviction rate or the acquittal rate would be higher. So I hope that as we hear the witnesses today, understand that it disgusts me. So much so that 2 years ago we do our nominations process for Service Academy nominees. About 2 years ago, I said, inspired in part by the concerns that you've raised, that I want this is a joyous occasion. These are young men and women who want to go to the service academies. You would generally want it to be a joyous occasion, hand them off a certificate and say, we're going to work hard to get you appointed. I have to dedicate about 10 minutes of that segment now, at my request, to talk about sexual assault and to make all those young people who are about to go into the academy understand that I'm watching them and I have high expectations. It's a shame that an otherwise joyous ceremony with these young men and women and their parents has to resort to that, but that's another step towards prevention. I want to make progress, but I want it to be something that's not the 227th bill that's gone through Congress on prosecution that doesn't ultimately address prevention. I want it to be something that we feel like can be implemented and bring as many people to justice as possible who are guilty or at least accused of being responsible for sexual assault. So I look forward to working with you. I want to take all of this data because as I do my homework, I hear people, it's like you've got the debaters in separate rooms and not coming together to make sure that whatever policy we move forward with is actually driven towards holding more people accountable. But I also hope that we have a treatment for more meaningful prevention efforts and also after an assault care. So thank you for holding this hearing. And without objection, I'd like to submit my formal statement for the record.
Well, thank you very much, Mr. Ranking Member. And I would just respond with 2 points. The reason why I think this legislative idea is so important is because a lot of rapists and sexual assaulters are recidivists. So if you want to prevent more sexual assault, put more recidivists in jail. So it is a measure of prevention. And 2, because I found that a lot of unfortunately, people mislead on this topic. The conviction of any, the rate of conviction since 2010, I'm going to read it off, going year by year from 2010 to 2019. Rate of conviction in 2010 was 24%, 2011, 13%, 2012, 14%, 17%, 16%, 15%, 9%, 8%, 7%. We are at 7%. Raw numbers, in 2019, we convicted 264 cases. In 2014, we convicted 433 cases. So these numbers really aren't going in the right direction, and so I wouldn't want you to be misled by any data that's incorrect.
Yeah, and I'm stipulating what I'm trying to do is figure out maybe people are talking past the numbers to numbers that are more favorable or less favorable. What I'm hoping to get to is something that as we pass these bills, we can actually start measuring on a consistent basis the progress that we're making. We're not making progress, but I just also want to say, I heard you say that it's an epidemic in the military. But it's fair to say with the same cohorts in society, it's even worse than that. I don't know what you call beyond an epidemic, but I don't want the young men and women who are considering going into the military to think it's a more dangerous environment, say the service academies, than what they're going to find in any fine institution across this country. I think it's very important to point that out. It's not unique to our men and women in military, and it's even worse for their cohorts in private institutions.
Thank you. I'd now like to turn to the first panel. Can each introduce yourself? Please turn on your microphone.
Okay, that good. Good afternoon, members of the Senate Armed Services Committee, Subcommittee on Personnel. Thank you, Senator Chairwoman Gillibrand and Senator Ranking Member Tillis, for having me here today to testify. Can I?
You may proceed with your testimony. Thank you.
Thank you, Chairwoman. My name is Natalie Kwam, and I'm an attorney, and I represent Vanessa Guillen's family. My background is I am a graduate of Georgetown University Law Center, proudly. I have an MBA in healthcare and a second master's in healthcare finance. I am the founding partner of Whistleblower Law Firm and Kwam Ripka Law Firm. I am here today to speak on behalf of not only Vanessa Guillen and her family, but all soldiers that are victims of military sexual assault and harassment. I agree with you, Chairwoman, it is an epidemic. I'm not here to put egg on our military. Actually, I love our military and I love our country. I'm an immigrant from war-torn Lebanon. My family is Lebanese Catholic. And the United States of America made this our home. They brought us in, they took us in, and I have a calling to help serve those who serve. I represent many members of the military. Senator Tillis, you probably remember me in your office a year ago with Sergeant First Class Richard Stayskull, the Green Beret, highly decorated Green Beret, who is dying of lung cancer. I represent many members in the military on all issues, including military-based housing issues. I know what's going on, I understand what's going on, and I speak here from truth. I am not a politician, I'm an attorney. There is such an injustice that's happened to our soldiers. Our soldiers deserve respect. Our soldiers deserve justice. We have to do this as a country, not just members of the military, but all people, civilians and all. As you know, there is no accountability right now in the military. I understand a lot of people have a loyalty to the chain of command, but it's proven a failure. It's proven to have failed, and we need improvement. I'm here to support the Military Justice Improvement Act. I'm here to support any kind of improvement, reform to the military so our soldiers have a voice. They have the rights that we all have, and they have the protections that they deserve. There needs to be accountability. You know, when I see these headlines and these soldiers that are committing suicide after being raped or assaulted or hazed, and I get these phone calls in my office from families asking how I can help their loved ones, their daughter or their son that's at Fort Hood and Fort Bragg, I sit there and I just think about how much is going on in our society and how many people don't get these calls that I get every day, all day. You know, we have had, the reason I've taken this case is as an immigrant, the Guillen family are immigrants. I knew that the DOD is a very complicated area, and that they were just going to be railroaded. They weren't going to get answers. They weren't going to get results. And I knew we needed one thing, and that was legislation on this matter. When I originally drafted the Richard Stayskull, Sergeant First Class Richard Stayskull Military Medical Accountability Act, sexual assault was part of that bill, and it was removed. That language was removed. So here we are a year later asking for accountability for our soldiers. They deserve to be protected. They deserve to be free to serve, free from sexual harassment and sexual assault. And I'm here to speak on their behalf for all those members of the military that proudly serve. What happened to Vanessa at Fort Hood, a 20-year-old beautiful young lady that just wanted to serve our country proudly. She was bludgeoned to death. She was murdered. A horrific murder that should never have happened on the base. Daytime in the armory room. And there was cover-up after cover-up, lies after lies. This family went through so much, and they're still going through it. Look at these reports that are coming out. They still don't have answers. We need change. We need legislation. I want to talk about not just through legislation. We need legislation that's actually going to create results. I speak from experience. When we had the Sergeant First Class Richard State School Military Medical Accountability Act passed last year, we still don't have our members of the military with rights to process their claims. It's stuck in the DOD's bureaucracy, and that can't happen. We can't wait for the DOD to do their job. You members of Congress, you need to pass this legislation. You need to do this for us. We look up to you. We need you. And I ask that you protect these men and women that serve like they protect us. I only speak because I know what I'm talking about, as do you. I know what they're going through, and I know what they say to me. And without any kind of improvement and revisions and reform, our members of the military are going to continue to be afraid to join. Senator Tillis, you are absolutely correct. We don't want to scare anyone from joining. I absolutely agree. But you also want to give them the morale to join. You want to say, hey, look, it's a better tomorrow for everyone. We're here to help you guys like you're helping us. We're here to protect you like you're protecting us. And I speak from the heart as an attorney, not as a politician. I thank you, members of Congress. I thank you for having me here today, and I'm very happy to answer any questions you have.
Thank you. Ms. Frank?
Chairwoman Gillibrand, Ranking Member Tillis. I'm sorry. Chairwoman Gillibrand, Ranking Member Tillis, and members of the committee, I thank you for this opportunity. My name is Amy Braley Frank. I have been working with victims of sexual violence since 2006. Currently employed as a victim advocate at the 416th Theater Engineering Command. I am currently being retaliated against for reporting command for illegally concealing and failing to report 3 violent sexual assaults to law enforcement. I have been on a paid suspension since 20 November 2019, the day after I emailed Lieutenant General Charles Luckey the evidence. I emailed the evidence to the Chief of Staff of the Army, General James McConville, on 22 November 2019. I also sent the evidence to the Chairman of the Joint Chiefs of Staff, General Mark Milley, and DoD SAPRO, Admiral Burkhart, and Nate Galbraith. This evidence mirrors what was documented in the Fort Hood report. Sexual assaults and violent rapes not reported to CID or law enforcement. There was retaliation against victims and reporters of crimes, no case management group or attendance for over a year. I have been left in this suspension after protecting my victims and reporting the command for over 16 months, completely ostracized and retaliated against. This evidence was reported to the Office of Special Counsel and the DoD IG. The Army's internal 15-6 process has impeded justice for my victims and myself. This internal investigative process does not allow for transparency and should be abolished. My whistleblower complaint was due to a 17-year-old private in the Granite City, Illinois Reserve Center that was raped, resulting in a broken collarbone and a broken arm. She had to stand next to her assailant in formation. The command's illegal 15-6 investigation was documented in a memorandum of record. They said it was consensual sex. For over a year, no one assisted her until I was notified in June of 2019. But after my suspension, her advocacy ended. Advocates are continually blocked by layers of command from protecting their victims. When commanders ignore advice of advocates, we have no recourse. There are no consequences for commanders when they violate the law. Documented by the number of murders and murders by suicide. Nicole Burnham's brigade commander, Colonel John Munford, left Nicole in the same barracks at Camp Casey with her offenders, raped and later gang raped, tortured for over 82 days before her transfer was executed. Nicole Burnham is dead. Staff Sergeant Morgan Robinson's first offender is still serving in the Oklahoma Army National Guard. Staff Sergeant Robinson's report of 9 Special Forces soldiers placing a covering over her head, dragging her out of a tent, and gang raping her in Afghanistan has never been investigated. An outstanding soldier committed suicide. She was not protected. Lavina Johnson's brutal murder has never been investigated. The Army still states it was a suicide. 16 years later, the toxic culture again exposed and the murder of Vanessa Guillen. This is not isolated to Fort Hood, documented across all components of the military. Fort Campbell, April 2020, Never Alone received a phone call from a soldier that was gang raped. She was illegally arrested by CID and denied counsel. Her special victims counsel, they told him that he was not the right kind of attorney. Major General Shadley retired. He alerted Major General Donna Martin. Nothing was done. Never Alone helped the soldier with suicidal ideations, but she is still fighting to clear her record. Fort Bliss, 31 December 2020, Private First Class Asia Graham was found dead. Her offender is identified as an accused serial rapist, walking free, no pretrial confinement. He continued to live in the same barracks, on the same floor with Asia, and was moved from Echo Company into Headquarters Company with his victim until her untimely death. Asia's leadership failed to protect her after she reported her rape in February of 2020, not June. Private Richard Holliday is still missing from Fort Bliss. When victims and victim advocates speak out about the broken process and illegal actions of commanders, we face severe retaliation. All felony crimes, murder, rape, sexual assault, domestic violence do not belong with the chain of command's control to investigate or prosecute. Kamisha Block's death was deemed friendly fire. She was murdered in a domestic abuse situation. The abuse of power is real. In Italy, the Provost Marshal, Lieutenant Colonel Michael Parsons of Army Garrison Vicenza, Italy, filed an espionage charge against in an Italian court against an Army spouse, Michela Morilato. Retaliation for exposing General Harrington, resulting in his firing and demotion. This retaliation was reported to then Chief of Staff of the Army, General Milley, and the IG. Nothing was done. Illegal internal 15-6 process, ability to redact investigations. None of us will ever know the truth or get justice. Just this week, my own sexual assault by a 2-star general, still under investigation, was improperly released to be weaponized against another sexual assault advocate that was assaulted by a full-board colonel in an unrelated court-martial. The military has no checks and balances. I was raised in the military, and I'm a proud mother of a veteran of the Army. I will not stop until our military is safe. Sexual misconduct is an abuse of power and a force protection issue. The inability of commanders to execute essential command functions of protection is a significant threat to the United States military's ability to protect this great nation. Soldiers should never be alone. Thank you. I yield to any questions.
Thank you. Our next panelist, Ms. Marsh. I just can't read that far.
Is it on? Oh, is it on? Can you hear me? Okay. Good afternoon, Chairman Gillibrand, Ranking Member Tillis, and members of the subcommittee. Thanks for inviting me here today. I appreciate the opportunity to speak about my experiences and my convictions. I would also like to thank my husband, Brian, for supporting me over these past 2 years of fighting for justice. I wouldn't be here if it weren't for him. I've been a military spouse for almost 4 years now, and in December of 2018, while we were at our first base, Travis Air Force Base, I was sexually assaulted by an E9. This was a person who should have been the highest example of the Air Force core values and whom my husband and I trusted and respected, even viewed as a mentor to my husband, a young CGO at the time. Instead, this person betrayed that trust when he sexually assaulted me after a unit function. This experience nearly destroyed me, our marriage, and it has ruined my husband's Air Force career. I kept my trauma secret for months because I had not yet understood what had happened to me. Once I understood this was a sexual assault, I was afraid of what would arise if I said anything at all. After careful reflection of what reporting this meant for me and my family, I decided to file an unrestricted report. We initially had hope because I immediately was assigned an SVC, and we had an expedited transfer to Davis-Monthan Air Force Base where I could be near family. Although my SVC persistently requested feedback from Travis Legal Office as to when they wanted a deadline on my decision on whether or not pursue charges, they did not give an answer until the day of the deadline. I felt pressured to give a quick response and requested administrative action instead of a court-martial. However, after giving it more thought, I decided, yes, I did want to pursue charges. The base commander, an 06, denied my request. I asked for a video conference with him and was denied. Instead, I was allotted a 10-minute phone call where I literally cried to him and explained why I needed to pursue charges. He did not say anything in response and still denied it. Immediately after my decision of wanting to pursue a court-martial, my husband was punished by his command because of allegations made against him by people who worked directly for the accused. He appealed this decision as high up the chain as you could go, but it remained on his record, and his promotion was delayed. To us, all of this felt like retaliation for having reported the assault and for not backing down when the command did not prefer charges against the offender. The only reason my husband's chain of command knew about the allegations that led to him being punished is because we made the decision to file the unrestricted report. My assailant only received non-judicial punishment and was forced to retire early. The order was issued by the 18th Air Force commander, disregarded at a lower level, and then had to be reissued. How is it that my assailant's only consequence was a decreased pension and retirement, but my husband's military career is essentially destroyed? The frustrating part is that everyone in the chain of command refused to provide me a response as to why this was, and they have all been up for promotion since then. After exhausting the chain of command, I filed congressional complaint with 2 separate offices in my state. The Air Force gave a consistent yet victim-blaming response. The Air Force claimed that the chaplain had encouraged me to believe the sexual activity was non-consensual due to intoxication. This is a gross mischaracterization of the drastically needed help my support system was giving me at the time, and an insult to anyone who has ever been assaulted while too incapacitated to defend themselves. But the most egregious of the Air Force's responses, to my case, was when an Air Force general had written that marital difficulties between Brian and me would, quote, likely undermine my case, end quote. I find it unfair how the Air Force considers a marital disagreement a potential disqualifier when reporting sexual assault. The Air Force promises survivors, quote, maximum support after reporting sexual assault, but that is not what I felt following my decision coming forward. At the end of the day, even though I begged this colonel, he decided 2 times not to prosecute the E9 who assaulted me, and it has been detrimental to my life and my husband's career. After it was all over, we felt the repercussions for reporting had been worse for us than my assailant, and the Air Force's rationale had finally come out that was indeed victim blaming. What if what had happened to me continues to go unchanged? Survivors will feel reluctant to come forward for fear that they too will face retaliation. It pains me to say this, but at many points throughout this process, I felt it would have been much better if I just hadn't reported anything at all. If the status quo remains unchanged, bad actors will be able to continue their military careers while victims suffer in silence. And I don't feel any justice or fairness in the system that has failed me, and I did everything right. Because of what we experienced, we have decided not to continue the military couple life that we really did once cherish. But I do hope that my testifying here today shows that we remain committed to helping improve justice for survivors and that it can finally become safe for survivors to report sexual assault in the military. Thank you.
Thank you. Our last speaker, Mr. Quentin McNair.
Chairwoman Gillibrand. The mic. Okay. Chairwoman Gillibrand, Ranking Member Tillis, survivors, advocates, ladies and gentlemen of this subcommittee, good afternoon. I'm a retired Army veteran with over 7 years in the field of victim advocacy. I currently call Chicago my home, where I own and run a small bakery business and volunteer at a nonprofit organization that serves the community. As a former sexual assault response coordinator for the 82nd Combat Aviation Brigade, I manage the unit's sexual harassment, assault, response, and prevention program alongside my fellow victim advocates. My primary duties included training, case management, and providing resources for over 3,000 soldiers. as well as revolving duties as the installation on-call SARC, participation in sexual assault review boards, and planning for installation events and awareness. Although I am retired, I will always consider those that serve as my brothers and sisters in arms. And right now they face an old enemy that's eating away at the integrity and a proud history of our armed forces. An enemy who takes its toll on and off the battlefield and whose wounds scar deep. This enemy is sexual assault. To fight sexual assault, we must continue to make strides to change the culture. As a SARC, I was at the front lines of that fight. I used sharp guidelines to create informative and open discussions about sexual assault. Soldiers responded well to that, and it resulted in a decrease in incidents and an increase in reporting in my unit. I see support and awareness everywhere, and we've come a long way from when I took my first class as a young soldier. However, I find this shift ineffective, especially if and when we fail at accountability. So what has changed without accountability? I can recall SHARP training early in my career where soldiers were taught things like never go out alone or to cover your drink so nobody could slip something in it. We were even passed out rape whistles. We essentially taught soldiers how to avoid being assaulted. The onus or accountability was not on the person committing the act, it was on the victim. I can see the culture has shifted. We now teach consent and intervention. But to end sexual assault, we have to do more than shift. We have to change the culture that feeds it. To change the culture that feeds it, we have to hold those that commit these acts accountable. Changing the hearts and minds of every single person who may commit sexual assault is a difficult task. I dare say an impossible task. But we do have the power to hold them accountable. People who commit sexual assault are like sharks hunting. You aren't aware of them until they attack. Through accountability, we can make the water so hostile to the shark that they are afraid to hunt. On the other hand, lack of accountability emboldens them. All of the efforts put into intervention by SARCs and victim advocates around the world are lost when we fail to hold people accountable. I do not doubt that the prevention of sexual assault and harassment is a priority for every leader in our armed forces. It's non-negotiable. Every leader is required to buy into the program, yet we continue to see examples where that priority is not evident. What is evident is that there is a large gap between the leaders who care because they're required to and the leaders who actually care. That gap is painfully obvious every time a case is purposefully mishandled. That gap is painfully obvious when things spiral out of control as they did at Fort Hood. And right there in the middle of that gap are the lives and careers of the soldiers who suffer from it. When a sexual assault is reported, the first call is made to CID, who, independent of the unit, starts a criminal investigation. The findings of that investigation are turned over to the unit for adjudication. While most commanders and their legal team handle cases with integrity, that response isn't uniform across the board. I believe this has been a point of failure far too many times. The effects of a mishandled case are far-reaching and the damage is irreparable. Maybe it's time to try something new. Perhaps the answer to restoring the faith of our servicemen and women in the SHARP and SAPR programs is to handle the adjudication the same way as the investigation, by an entity outside of the unit where the incident occurred. Sexual assault and harassment are issues that span mission and personnel readiness, unit cohesion, battlefield effectiveness, and many other areas. In combat, I have to be able to trust my leaders and fellow soldiers with my life. That trust withers or dissipates altogether when I can no longer trust those same people to protect me at home. I dedicated 24 years of my life in service to this country and its values. I am very disheartened that the U.S. military, where the best of the nation called home, has a problem with protecting its women and men. How do I encourage others to make the same sacrifice I made when I cannot guarantee their safety? Not from foreign enemies, but from their leaders and fellow service members. I have 2 daughters, ages 20 and 23. Their names are Destiny and Tiana. They are extremely proud of my service and at one time both considered following in my footsteps. Sadly, I discouraged them because despite the honor of wearing a uniform and all the benefits that come along with serving, there is no honor in going to combat and coming home to be assaulted by the same people you fought beside. I've seen it firsthand, and no benefit is enough to heal the emotional scarring that comes with that. Thank you for your time and the opportunity to share my thoughts and experiences. I sincerely hope that this committee can work together to find a change that's needed to resolve this issue.
Thank you very much. Thank you to all the witnesses for your profound testimony. I'd like to ask a couple questions. Ms. Quam, you have represented victims of crime in the military across a long period of time and also in different circumstances. As their representative, what can you tell us about their faith in reporting crimes to their commander and having the chain of command make the decision about whether a case should be brought to trial?
Thank you for your question. Thank you for your question, Senator, Chairwoman. The victims that I speak to on a daily basis tell me how fearful, like Vanessa was, to report the crime that they've experienced. They're challenged by the seniority. You know, statistics show, as Senator Tillis likes to hear, the more younger that they are, the more likely they are to be a victim of sexual harassment and assault. And because it's still within the chain of command, you have a bias with somebody that you're put in a more senior position with. So the perpetrator is usually going to be somebody that has a better, more approachable relationship with the command than the young specialists like Vanessa Guillen. So reporting has 3 issues. A, will I be believed? B, am I betraying my brother or sister, whoever is the assailant? And C, why are you reporting this? Are you sure this happened? Were there any witnesses? Suck it up, buttercup, those kind of responses. And worst of all, they know the retaliation that goes with it for reporting alone. The reporting itself becomes its own animal. You become a victim, you become re-victimized as a victim, because now you're put through this channel of questions, doubt, character assassination. You heard it from the other witnesses here. So the way that right now the system's set up, it's obviously, we all know it's proven to be a failure. The need to take sexual assault out of the chain of command is a necessary and important step to give some kind of assurance to our victims and our soldiers. And the morale is really low right now. And we need to change that morale for our victims and for our soldiers in general, giving them a voice and believing them and letting the system, an independent system, take place, not through the chain of command.
I appreciate that Vanessa's family is here. Could you talk a little bit about what the climate was like at Fort Hood, what Vanessa told you, what you know of that climate? Was her statements to you or to her family different than what the Fort Hood report just came out with?
Yes. When I was retained by the Guillen family, Vanessa was missing at the time. We didn't know where she was, and I came in to help find Vanessa. Unfortunately, as we all know, she was murdered. But her statements to her family and her friends, and actually her fellow soldiers, were that she was being sexually harassed. She did not like the way they were talking to her. They were saying very inappropriate, vulgar statements. And this was several of her fellow soldiers, sergeants, that did this to her. And unfortunately, her concerns were, as she told her family, my clients, that she was afraid to say anything because she was afraid they wouldn't believe her and that she would just try to fix it or handle it herself. You know, we saw what happened when she tried to handle it herself. She was bludgeoned to death. So I don't know if this system really works when somebody's either going to be assaulted and keep it to themselves, or they report it, or as she said, she was going to report it, and the assailant didn't want her reporting. He killed her. Or the other victims families that I speak to, they kill themselves because they don't know what to do. And they don't want to be, as you heard, re-victimized by the system.
Thank you. Mr. McNair, thank you for your testimony today. In your written testimony and in your oral testimony, you discussed the difference between actual buy-in from military leaders versus forced buy-in. Can you explain for the members here what you mean by that and why it's important in combating sexual assault?
So when I speak of forced buy-in or required buy-in, it is written in every doctrine that we have that there's a zero tolerance for sexual assault in the military. We hear it all the time. We hear it at these hearings that there is a zero tolerance for sexual assault. There's not a single commander or leader in any branch that will not say, hey, this is not a top priority for me. But if that is true, then why do we continue to have situations like what happened at Fort Hood? Why do we continue to have mishandling of cases? So it's extremely important that we find leaders who have that actual buy-in, who buy into the program because they actually care about their soldiers. They care about the well-being of the women and men in the armed forces versus the leaders who say, hey, I care about this because I'm required to.
Senator Tillis.
Thank you, Chairwoman Gillibrand. Ms. Marsh, when you reported sexual assault, can you give me any idea of the support that you got just recovering from the trauma?
Yes. Thank you for the question. I did receive help from a victim advocate when we were still at Travis, as well as an SBC, and then we moved to Davis-Monthan, and I received support from a victim advocate temporarily there as well as an SBC. I think Special Victims Counsel. She was my lawyer, essentially. But I did receive support from them. The commander did check in on me once, but not since then. Yeah.
You mentioned that your husband's promotion was delayed. Over what period of time did that occur? Has he been subject to any other promotion since then? He is still
still
active?
Yeah, he is still active duty, yes, sir. Yes, his promotion, he was supposed to be promoted in June of 2020, and it was delayed. And it still is delayed.
Ms. Quam, thank you for advocating for veterans and the time you took in my office. Are you aware, as I'm trying to sort this out to make sure that we're making positive progress on priorities that each of those all witnesses have expressed an interest in, are you aware of other jurisdictions that have made this change? And I'm talking about outside of the United States. I've heard, again, I'm trying to get my head around the data to make sure we have a positive outcome. But I've heard reports from Canada saying that they're having problems now with their transition. I think it was Australia as well. Are you familiar with studies that just support that doing this has a best practice or an example where the policy's been changed, it's been executed, and produced the results that we all want?
Senator, I studied the different military systems of our allies, such as Canada and the UK, and I've seen that the way that they've handled their military, their military do have, for example, in the United States we have the Ferris Doctrine. They don't have the Ferris Doctrine or anything like that overseas. Quite the opposite. In Canada, for example, it's a socialized healthcare system, and in their system, it's harder as a civilian the bar is higher to pursue a medical malpractice claim. Yet it's a lower bar if you're in the military to pursue a medical malpractice claim. Quite the opposite in the United States. So you see that overseas, and our allies especially, the way that they provide justice and rights to their military, a lot more than we do for our military in the United States.
Mr. McNair, I mentioned in my opening comments that members of the DOD, either service secretaries or various people in different levels of the chain of command, will use data that says we prosecute more, therefore our conviction rate is lower. What kind of insight can you give into me that say that's a red herring?
Well, when you look at situations where you have less people reporting, but you have less, prosecutions out of those reporting, and it skews the numbers, you can't really say that, we're doing more there. There's always the question of when in my unit, are we reducing numbers of actual sexual assaults, or are we reducing numbers of reports? So one thing you do have to consider is, has the chain of command or has the environment become so toxic that less people are willing to report, or are we doing enough now that it becomes so great that less sexual assaults are happening? And there's no way to really determine that unless you talk to the people that are on the ground. You have to talk to the local SARCs and the victim advocates who are actually out there in the unit with the soldiers to figure that out.
Thank you. Thank you, Madam Chair.
Thank you, Senator Tillis. Senator Hirono from WebEx.
Thank you, Madam Chair. So, Madam Chair, I want to thank you for the persistence of your advocacy and dealing with the issue of sexual assault, harassment, and retaliation in the military. And in that, I have been proud to join you. Now, the scourge of sexual harassment and assault has been since, as you said, time immemorial. And so the military keeps trying to make improvements, but we do not see improvements. So here we are with yet another 90-day commission to come up with some suggestions. And I do think that some of the previous 90-day commissions have made suggestions. And in fact, I think one of your panelists will talk about a GAO report, which contains yet more suggestions. So this continues to be a huge problem. I think what some of you may have mentioned that the context in which we are operating is that sexual harassment assault is really an issue that is a scourge in the wider community, not just in the military community. So do any of you have any thoughts about what we can do from a cultural standpoint? You know, how we can, let's just talk about the culture in the military. How do we change the culture in the military so that the scourge is not only to be prevented, but to be prosecuted and to be basically to have people in the military recognize that they have to change their attitudes about sexual assault. Do you have any suggestions on how we can do that in the military? Any of the panelists?
Yes. Is my mic on? Yes.
Jump in.
Yes, Senator Hirono. I believe that we have got to continue to have these open conversations in the training environment. The training needs to be changed. We have to have senior leaders be accountable to be engaged with that training, that the special victims councils and the victim advocates need to be in their own command so that they cannot be harmed when they are fiercely advocating for their clients. That's a simple move to mirror us like CID. That way we can not be encapsulated. And I think it's very also important to point out, and all the Gold Star mothers that I talk to, is that when their children, their soldiers, were deployed or out of the country and being sexually assaulted, they have no bug out plan. They can't just go to a rape crisis center when they're in Afghanistan. They're not like a college student. They can't say, Mom and Dad, come get me. You know, Stacey Burnham, her daughter, for 82 days, she said, Mom, just stop asking me. Nobody can help me get out of here. Just stop asking, Mom. So if they leave without permission, they're AWOL. So they're not like college students. They can be prosecuted if they just leave to make themselves safe. Asia Graham received an Article 15 for getting an apartment off post. So we've got to change and get some transparency, because without transparency, we cannot have culture change. Thank you.
I did ask all of the panelists, but I'm running out of time, and I assume that your comments will be similar in terms of the steadfastness with which we have to pursue the kinds of changes that we need to pursue. I do have one question for Natalie Kawam. You are the attorney for the Guillaume family. So are you familiar with the I Am Vanessa Guillaume Act that I will be reintroducing this Congress?
Yes, I am, Senator, and thank you so much for supporting our bill.
So one of the provisions here, and I'd like to ask Ms. Marsh, because you are a survivor and your husband's career was also very much detrimentally impacted by your coming forward. So do you have any capacity to file a claim in civilian court to pursue your redress?
That I am not quite sure of the answer to that one. I believe.
Ms. Cam,
Oh, sorry, go ahead.
Ms. Karam, do you know? I mean, that right now, because of the Ferris Act, the active duty personnel are prevented from pursuing their claims in civil court outside of the military. Isn't that right?
Is that for me, Senator?
Yes.
Yeah, so Senator, I wanted to answer your question. Ms. Frank gave a great answer, but I'm going to tell you what I see the differences between, I say the civilian world versus the military, and this answers Senator Tillis's, or this is to Senator Tillis's statement earlier, which is, you know, you have sexual harassment. This is a culture not just in the military world, but it also exists in the civilian world. Absolutely correct. But the difference is in the civilian world, someone like Harvey Weinstein, who sexually assaults or harasses one of his employees or such, underlings, will be sued, will have to answer. They don't have to go through Harvey to get justice. They go through an outside organization such as the EEOC or such. In the military, they don't have that option. They have to go through the command. So it's an internal conflict on so many levels, and it's a biased system. And that's why we have the problems we have. Secondly, the Ferris Doctrine bars our military members from being able to pursue a claim or have retribution or indemnification that we all have as civilians. So we need to, as we did with the Richard Stay-Skull Military Medical Accountability Act, where we made a narrow exception to the Ferris Doctrine, we need to do the same, provide the same rights to our victims of sexual assault and sexual harassment.
I agree with you, and that's one of the provisions of the I Am Vanessa Guillaume Act, and I think we need to enable victims of sexual assault harassment to be able to pursue their claims outside of the military tribunal and process. Thank you very much.
Thank you, Senator.
Thank you, Senator. Senator Hawley.
Thank you, Madam Chair, and thanks to all of the witnesses for being here. And I want to say especially thank you, Ms. Marsh, for being here and being willing to tell your story. I know that that's not easy. Mr. McNair, could I begin with you? You were a sexual assault response coordinator. In that capacity, which programs did the victims who you worked with find most helpful?
So I've seen it time again at these hearings where we talked about the Special Victims Council. Once that was finally enacted and when it worked as it should, it was one of the best things we had going. We often had issues of getting a Special Victims Council in a timely manner because they just weren't available. We had so many cases going on at Fort Bragg and such a small pool to pull from. There were times we had to borrow from other units. Also, the ability to forego the military all at once and visit places like the Rape Crisis Center for help. I've had soldiers who would come and they didn't want to have anything to do with the chain of command, but they still wanted that help so they could get back into the fight. So our relationship with outside resources like the Rape Crisis Center in Fayetteville was a great asset to our soldiers.
So you, just on the Special Victims Council, you found that the victims you worked with found that particularly, that program and those resources particularly helpful. Is that fair to say?
Yes, sir.
But you said just a second ago that you had, in a number of circumstances, difficulty in getting a timely assignment of a council. You said sometimes just because there weren't enough of them. Were there other things, other log jams that created a lack of access to these council?
I mean, it's been about 2 years since I retired, so it's I would have to sit down and try to recall. But that there were numerous roadblocks that I, as a SARC, and my team as victim advocates would try to work around. Sometimes it took a while to get them the mental health that they need because, once again, overwhelmed with the number of survivors who needed some kind of mental health counseling, and sometimes their appointments would be weeks or months out.
Wow. Yeah, that's incredible. What are, from your point of view, Mr. McNair, what are the most important things that Congress or the Department of Defense could do to strengthen the prevention of military sexual assault? So
the skills that victim advocates and SARCs develop, they develop over time. The longer a person does their job, the better they are at the job. My best asset as fresh sergeant first class stepping into the job was my victim advocate who had been doing the job for 3-4 years already. So the problem is we train them, we give them this experience of speaking, we give them these tools and assets, and in 2 years, most likely, that service member PCSs and goes somewhere else. So you have to start that cycle, that relationship again. So with our retention in the military, we made retention its own MOS. Recruiters are their own MOS. They get to build upon those skills, and they take those skills with them to the next unit. I feel like we should probably do the same thing when it comes to victim advocates and SARCs. So once we give them that experience and that skill set they need, even if they go to another unit, now that unit can benefit from the same thing.
That's really helpful. Thank you. Ms. Marsh, let me just, in the little bit of time I have left here, let me just ask you, in your own case, in your own experience, would it have made, do you think, a big difference to have had the decision whether or not to move forward with the prosecution be vested somewhere other than the unit commander? I mean, do you think that and maybe say if you know or say if you don't know, but I'd just be curious what your own experience is there.
I do believe that would be, yes, I believe that would have been beneficial.
And can you give me a sense of why that is? I mean, why do you, based on what you've been through, why does it seem like that would have helped?
We could possibly still decide to make an Air Force career. We would have probably still stay in the Air Force if that would have happened.
Very good. Thank you for your testimony. Thanks to all of you for being here. Thank you, Madam Chair.
Just checking that Senator Warren is not on WebEx. Okay. We'll transition to the second panel. Thank you so much for your testimony. If there are any further questions from any senators, they can submit it to the witnesses and they can provide it in writing. Your testimony truly matters, and I'm very grateful for the time you took and the willingness to share such difficult issues with all of us. Thank you. We will now transition to the second panel. We will hear from our government witness, Ms. Brenda Farrell, the Director, Defense Capabilities and Management, Government Accountability Office. Ms. Farrell, you can start your testimony. Please put your mic on. Thank you.
Thank you. Madam Chairwoman, Ranking Member Tillis, members of the subcommittee, thank you for the opportunity to discuss issues related to congressional oversight for prevention of and response to sexual assault incidents in DoD. As you know, sexual assault is a heinous crime that contradicts the core values that DoD expects their service members to follow, such as treating their fellow service members with dignity and respect. Since 2004, Congress has continually taken steps to address sexual assault in the military. GAO has issued numerous reports on DOD's prevention of and response to sexual assault and have made over 100 recommendations. Despite sustained congressional oversight and DOD actions, reports of sexual assault in the military continues to rise, totaling approximately 6,200 in fiscal year 2018. My written statement is based on ongoing work identifying, among other things, the statutory requirements related to sexual assault prevention and response in the military contained in the National Defense Authorization Acts from fiscal years 2004 through 2019, and our prior work in the area. I will briefly summarize my written statement that is presented in two parts. The first part of my statement describes the statutory requirements concerning sexual assault that were contained in the NDAAs from 2004 through 2019. We found that Congress enacted 249 statutory requirements related to sexual assault prevention and response to assist DOD in its efforts in this area. Most of these requirements are still in force. These statutory requirements covered a number of different activities. Some examples are that NDAA for 2007 required annual reports on sexual assaults at the military academies and within the armed forces to aid with oversight. The NDAA for 2011 required the establishment of a training and certification programs for sexual assault response coordinators and victim advocates. The NDAA for 2012 required that the director of the Sexual Assault Prevention and Response Office be at the general or flag officer level or senior executive service level. Other requirements have concerned the development of comprehensive policies and procedures. Although the requirements cover a wide range of activities, we found that they generally related to two broad categories. First, victim assistance and advocacy. Second, management and oversight. These two categories cover 70% of the requirements. A smaller percentage of requirements, 9%, were related to prevention efforts. The second part of my statement discusses whether there are areas where DOD can provide further focus to address sexual assault. While DOD has taken a number of considerable steps to address sexual assault, GAO's prior work has shown that there are areas in which DOD can focus to further the issues. With exception of some more recent initiatives, DOD's efforts have been largely focused on responding to rather than preventing incidents of sexual assault. For example, we found that the department had not fully developed performance measures to assess the effectiveness of its sexual assault prevention efforts and make changes when needed, and recommended that it do so. Recent DOD efforts in this area, in addition to congressional oversight and implementation of prior recommendations, could help DOD reduce the incident of sexual assault. Further, additional actions are needed to strengthen DOD's efforts to address the needs of male service member victims who have been sexually assaulted and the needs of DOD's workforce of nearly 900,000 civilian employees. For example, GAO found that DOD was not tracking all reported work-related sexual assaults involving civilian employees and recommended that it issue guidance to help ensure more comprehensive tracking. In summary, greater focus on preventing sexual assault incidents for all of DOD's workforce, military and civilian, regardless of gender, could help reduce the number of incidents in the department. Madam Chairwoman, that concludes my summary. I'll be pleased to take questions when you're ready.
Thank you so much for your testimony, and thank you for your work. As you noted in your statement, despite sustained attention on the issue of sexual assault in the military by both Congress and the DOD, reports of sexual assault have continued to rise over the past decade. The Fort Hood Independent Review Committee report issued in November 2020 found that implementation of sexual assault prevention and response efforts at the installation was ineffective, and that the Army's Sexual Harassment Assault Response and Prevention SHARP program is structurally flawed. Why are current efforts to prevent and respond to sexual assault in the military falling short? And how can DOD take more effective approach?
We are continuing to monitor the actions that DOD is taking in response to the Fort Hood recommendations. I note that in the Fort Hood investigation, accountability and leadership were highlighted as issues of concern. We know that commanders play an important role with climate assessments, and we have previously recommended that there be a mechanism to track the commander's compliance with conducting the client assessment surveys. This has been a longstanding issue. There have been other actions taken to try to encourage commanders to use this tool. But this is very important because commanders can influence a unit or an installation, and they can encourage by supporting and promoting and enforcing the policies and the programs of the sexual assault prevention and response. So that is definitely one recommendation related to the climate environment as well as the leadership that crosses with what the Fort Hood investigation found.
So why, in your opinion, are commanders not doing that, since they've promised to do that for the last 10 years we've been focused on this?
We have found that, like I said, when we did our site visits at military installations years ago, some commanders did not conduct the surveys. It wasn't a priority. We made that recommendation. We've been tracking it. We note that it has been picked up as a statutory requirement. This is something that could aid commanders in assessing the climate that they inherit. As to why they're not doing it, I would have to say at this time we don't have any information that's more available to answer that question.
You noted in your statement that since 2004, Congress enacted 249 statutory requirements related to sexual assault prevention and response in the military. Further, GAO has made over 100 related recommendations to DOD, dozens of which remain open. What else should DOD be doing to prevent and respond to sexual assault and the full continuum of unwanted sexual behaviors? Despite all of these changes, we've actually seen no change in DOD's ability to actually prevent sexual assault. What authorities does DOD need that we haven't already given them?
We would like to see DOD implement the recommendations from our 2015 report to further develop their prevention strategy. In 2015, DOD decided to use a model that was evidence-based from the Centers for Disease and Control to develop a prevention strategy, and we assessed that strategy with CDC's criteria. We found that DOD had taken steps to do what the model suggests, identify the domains that service members are in, and that CDC had noted is individual relationships as well as the society. DOD added 2 domains that service members are in that are unique to the DOD environment, that being the military community and leadership. DOD did follow through with some of the risk protector factors. The CDC recommends that risk factors be aligned with each domain. DOD aligned risk factors for the 3 that CDC had recommended, but for the 2 domains that they have the most control over, the military community and leadership, they did not align what those risk factors are. For the protective factors, they did not align those protective factors with the domain. They did identify the protective manners, but it was collective. If DOD would follow through and align the risk and protective factors, the research that the CDC has done shows that then the agency could take steps to mitigate the risk factors or enhance the protective factors, thus reducing the incidence of sexual assault.
You said these recommendations were made in 2016?
2015.
2015. So we've had 6 years to begin to think about actually doing the prevention that you recommended after doing a thorough review. So again, it's not that we haven't given them ideas on prevention, it's that they will not implement the ideas on prevention that the GAO in fact gave them. Senator Tillis.
I'm going to defer to Senator Tuberville and come after Senator Rono, who I believe is still online.
Thank you.
Thank you very much, Senator Gillibrand. Thank you for your hard work on this very important matter. Thank you, Ms. Farrell. Thank you for being here. I think we can all agree on 2 things. Sexual assault and harassment are unacceptable. I've been in coaching all my life, dealt with a lot of it, and it's an ugly part of our society. We've got to do everything we can to get rid of it in our military. Ms. Farrell, there seems to be a view that the Department of Defense does not care about sexual assault. In your many engagements with the department, personnel and service members members on sexual assault, do you get a sense that the issue is not important to them?
We think that there are a number of actions that Congress has enacted through law, as well as GAO has recommended that DOD can move forward with. And it's beyond a roadmap now because this is growing. There's so many roads and so many avenues that they need to address. We have seen leadership in DOD on this issue. I have met with the director of the Sexual Assault and Prevention Office, which is, as I noted in my opening, is usually at a general office level. It used to be at a GS-15 level. I think when that was raised to the general officer or flag officer level, that gave a voice to the senior leadership. We want to see, though, more put in place in terms of the framework with metrics so that when the leadership changes over, there is a framework in place, regardless of what happens with the leadership, that can make sure that not only the victims are being attended to, but that the incidents of sexual assaults are being prevented.
Yeah, when leadership changes, sometimes you have problems. People have different views. In your view, has the DOD been lying or attempted to mislead Congress about taking this matter seriously? Do you believe that?
We have a good relationship with the SAPRO office. They have been overall very cooperative in responding to our requests for information. As noted, we have an ongoing review that we've had to collect a tremendous amount of information from the department, and they've been very cooperative. As far as the leadership go, the leadership is key for prevention. That is one of the areas when we were analyzing the requirements that we look for. We look for leadership for prevention, we look for the climate for prevention, and we look for education and training. So the leadership does start at the top, and we have seen with the current SecDev some increased focus on prevention, and that leadership goes all the way down the chain of command.
Do you feel good about that? The leadership and what they're doing? When we have changes, do they usually step to the front on this, or they take a long time to look into matters? You know, I've been in situations before where sometimes people let other people make decisions, and somebody's got to start making a decision on this. And sometimes leaders don't step up front and do that. And it looks like to me our military should be full of leaders to make decisions on this to stop this. And so I know everybody gets frustrated. I'm a military brat. My dad was a military all of his life, died on active duty, and saw some of this. And this was years and years ago. And so sooner or later, somebody's got to find an answer to this. And it's got to start at the top. Our leadership has to make decisions and make decisions to make sure that our men and women are safe. Thank you very much. Thank you, Mr. Chairman.
Senator Tillis. Oh, Senator Hirona via WebEx.
Hello.
There you go.
Okay, thank you, Madam Chair. Thank you, Ms. Farrell. I know that you referred to a 2015 GAO report, and it appears that there were aspects of the recommendations that were not followed, and I was very curious about the fact that DOD was supposed to assign risk factors alignment with each domain, and I think you said that two domains, military, community, and leadership, these two domains were risk factors were not identified. Why not? Those seem to be really big areas where the risk factors should have been identified, wouldn't you say?
Yes, that's key in order for them to complete their plan for prevention. DOD issued another prevention strategy in April 2019. We've reviewed that strategy to see what it says about risk and protective factors, and it's silent. It doesn't repeat the information that there was there before, and it doesn't expand upon the information. We have had conversations with DOD about the risk and protective factors. We do note that they are including questions in their climate surveys about the risk and protective factors, but it's not clear to us how that is going to be integrated with their preventive strategy. So this is an area that we continue to monitor and have conversations with DOD to see how they're going to follow through on this particular aspect.
So are these climate assessments, climate surveys routinely done, and what kinds of questions are asked? Are there very specific questions as to whether anyone has ever been the victim of a sexual harassment, sexual assault, or retaliation? Are there those kinds of specific questions in the climate assessments?
There are standard questions that are asked in the climate surveys, regardless of where the commander is. The commander, I think, does have the opportunity to have additional questions if they wish. It is my understanding that there are some questions on sexual assault currently in the climate survey.
Are they standard? Are these climate surveys standard throughout the military? And the kind of questions that we're talking about that need to be asked?
Yes. There are a standard set of questions that are used to survey the personnel at a particular location.
No, but there are actually standard sexual assault kinds of questions.
Yes.
And then they're supposed to get this and then do something about it based on the responses that they get. So going back to the risk factor alignment. So what would be, I don't understand, can you describe to me how a risk factor alignment would work for a leadership domain? If I'm phrasing that correctly.
Sure. The two domains for which we have not seen risk factors, the military community and the leadership. I'll give you an example of the leadership, the military community first. This is something that would be unique to DOD, the active component versus the reserve component. Mm-hmm. So it's what are particular risk factors that are unique to the active versus the reserve component. There could be risk factors also for communities, such as the pilot community versus the medical community. For leadership, the risk factors could be, again, at different levels of command leadership. There's more decision-making or that the commander is responsible for. But these are factors that GAO would not determine for DOD, that DOD should determine. It is interesting, DOD did identify the military community as well as leadership as domains that they needed risk factors for. But they have not followed through from the documentation that we have reviewed or the conversations.
So I'm running out of time. I have to conclude that if the military identifies risk factors based on evidence, et cetera, that they will therefore try to minimize these risk factors. Correct?
I'm sorry, say that again, please.
If the military identifies risk factors that are attendant to these particular domains, then that would enable them to minimize those risk factors.
That's correct.
Right? Yeah.
Yes, ma'am.
And if they don't even identify them, then there you go. So can you think of any other example where Congress enacts 249 statutory changes over 17 years to address the problem? And here we are, 17 years later, and there seems to be a little progress being made. Can you think of any other situation where this is the case?
Well, we're looking at the extent to which they've implemented those 249 requirements, and that'll be the next piece of this puzzle, what has actually been implemented and the extent to which it's been implemented. So just because there's 249 requirements doesn't mean everything has been done. That is part of our ongoing work that we're trying to determine.
Yes, clearly not, because otherwise we won't be having this hearing. And another thing, I think it would be important to disclose the names of the people who are on the 90-day Sexual Assault Commission. And with the indulgence of the chair, I would just like to say that the GAO report is shocking, and over the last decade and a half, we've worked faithfully with DOD to address this issue. Unfortunately, the facts are the facts, and it's clear a bold new approach is required to instill trust in how the military responds to and adjudicates sexual violence in the ranks. And it's time to give professionally trained lawyers, military service judge advocates outside the chain of command the authority to make court-martial adjudication decisions. And in my view, it's the only way we can ensure our service members, especially those junior in the ranks who are most at risk, have enough trust in the system to come forward and report. And we owe it to them to act now. And thank you once again, Madam Chair, for your leadership.
Thank you, Senator Hirono. Senator Tillis.
Thank you, Madam Chair. Ms. Farrell, the studies by the Department of Defense and the RAND Corporation suggest that unwanted sexual assault and other similar behaviors are part of a continuum of harm. Can you explain to this committee the meaning of that term?
The continuum of harm is a term that's used by many research organizations, not just DOD. DOD defines it as an integrated, inappropriate behavior that is sexually misconduct. These that can lead to incidents of sexual assault and promotes an environment where such behavior is tolerated. So what does that mean? That means that sexual harassment is often used as an example that's on the continuum of harm. We have seen studies where service members who have been sexually harassed or have experienced gender discrimination have higher rates of sexual assault than those who have not experienced sexual harassment. We've also seen a study where 1/3 of the service members who were sexually assaulted were first sexually harassed by their perpetrator. So looking at the continuum of harm is a way to try to understand all sexual violence and the interplay amongst those different aspects and how to go about preventing it.
To what extent do you think the DOD has made progress on addressing the behaviors on the continuum of harm?
We looked at their continuum of harm draft strategy a few years ago. We had some conversations with them. We issued a report on where they stood with sexual harassment and the continuum of harm at that time. I think that was around 2017. What DOD shared with us about their continuum of harm overarching strategy was missing many of the key factors that we would expect to see in such an organizational transformation type strategy. It's basics that I'm sure you're familiar with: clear goals, clear deadlines, metrics, and DOD was very receptive to the recommendations that we made, but they have not issued such a strategy at this time.
So they were receptive to the recommendations. What time frame was that?
That was about 3 years ago, sir.
And is there any evidence that although they were well received, that they've been acted upon on a systematic basis?
We have not seen anything in the last year. We know that they believe more research was needed, and we're working toward that, but we are still waiting to see if they actually have a strategic plan on the continuum of harm to issue.
And the written opening statement, I alluded to it in my comments before the first panel, but of the 249 requirements that the GAO has assessed have come out of past congressional action, it seems to me that only a minor portion of it, about 10% of all those requirements, have anything to do with prevention. Do you believe that there are other things that we should consider beyond what's already been recommended, or in your opinion, is it just an unacceptable recommendation of the requirements set forth by Congress?
Well, sexual assault crosses many functional lines. There are so many organizations involved, the healthcare, the legal, besides the immediate care through the victims' advocates or the SARCs for the victims. We would like to see, as I've noted, all of the statutory requirements actually implemented as well as our recommendations. But we do think that the recommendations in our prior report on preventing sexual assault could help DOD reduce the number of incidents. So we are pointing at those particular recommendations in terms of preventing sexual assault.
Thank you. Thank you, Madam Chair.
Thank you, Senator Tillis. I just had one follow-up question. Do you know, Ms. Farrell, how much the Department of Defense has spent on addressing sexual assault in the military, including the military justice reforms, victim support, prevention, and response?
No, ma'am, I do not have a figure on how much they have spent.
Would you be able to provide an estimate with time and submit it to the committee?
We can definitely check into that and see what is available in terms of the amount spent.
Also, I noted in your earlier testimony that you said that you recommended that we begin to track the civilian cases. And that's one of my concerns for a very long time, because in the estimated cases of 20,000 and whatever the last date, 2018, we estimated, the DOD estimated there was 20,500 cases. That estimate does not include civilians. It only is an estimate based on service members. And when I've had the privilege of reviewing the records of cases at each of the four largest bases, one for each service, I've noted and during some years that about half of the cases that were reported were civilians. And so if that's true, then you might have double that of estimated cases. Is that your understanding?
The number could greatly be understated because of not including the incidents with civilians. You're right. And our report notes that there are gaps in the guidance that lead to very little visibility about the number of those incidents.
Thank you. Senator Tillis, do you have any follow-up?
No, thank you.
Thank you so much. I appreciate your testimony. We're now prepared for the third panel. Thank you very much, Ms. Farrell.
Thank you.
Our next panel, we will hear from Colonel Don Christensen, United States Air Force retired and President of Protect Our Defenders, Mr. Eugene Fidel, Senior Research Scholar, Yale Law School, and Adjunct Professor of Law at New York University Law School, and Colonel Lawrence Morris, United States Army retired, Chief of Staff and Counselor to the President of Catholic University of America. Thank you, gentlemen. Mr. Fidel, would you like to start with your testimony?
Yeah, thank you very Thank you very much, Madam Chairperson. I'm going to make a few very brief comments. I'm more anxious to hear the committee's questions and to try to grapple with them than I am in giving a speech. I've prepared some detailed testimony, which I hope, along with the exhibits, can be made a part of the hearing record.
Without objection.
In my opinion, there are cogent reasons to transfer the disposition power from commanders to lawyers. I want to make four very brief observations in this regard. Number one, from my perspective, the highest value is public confidence in the administration of justice. And the public in that sentence is not only people within the military, but the rest of the American public. If there isn't confidence in the administration of justice within the armed forces, both the American public and people in the military workforce will have every reason to be disappointed in the performance of government. Needless to say, the impact of a fall-off in public confidence in the administration of military justice would be felt in accessions, retentions, and performance of duty, as well as in political support for military activities, for the national defense program of this country. The second point I want to make is that transfer of the disposition authority, that is to say, the power to decide who gets prosecuted for what and at what level of gravity, is sensible. Non-lawyer commanders, and today nearly all commanders are not attorneys, are ill-equipped to make the kind of increasingly complex legal decisions that the military justice system requires. And I can highlight a few of those. How able, for example, would a non-lawyer decision maker be at the arcana of social media, which play a remarkably salient role in the military justice throughput these days? Metadata, free speech issues, including extremist speech, timely subject, urinalysis issues, or another scientific issue, hair analysis used in drug prosecutions, the right to confront witnesses, a very arcane subject of constitutional law, computer fraud, child pornography, which seems to be, talk about an epidemic, there does seem to be an epidemic of child pornography in the armed forces, mental health issues. All of these are hardly what you would call the bread and butter of military command. They're much closer to involving the kinds of skill sets and analytical tools that lawyers are called upon to bring to bear. Commanders also have other things competing for their limited time and attention. And I would argue that typically those other things are going to be more urgent, pressing, and geared to their skill set than the kinds of matters that come across their desk in their current role as convening authorities, those few who actually are convening authorities. Third, commanders' decision-making may at times be skewed by self-interest. It's not good for a commander in career terms if there's a crime epidemic in the unit, if the command climate is poor. These are things that the services track very closely, and they do impact on commanders' career opportunities, for example. Similarly, a commander may have an interest, for example, in preserving the viability of a fighter pilot in whom the taxpayers may have invested a fortune in training costs, or a very senior non-commissioned officer, a staff NCO or a Master Chief Petty Officer. These are valuable people, and a commander may be loath to give up the utility of such a member of the command. There's been a question as to whether transfer of the authority to dispose of charges would deprive the decision maker of the benefit of command insight. And the answer is absolutely not. Commanders can and should be heard if there are command-specific considerations that call for a particular outcome. If there is an epidemic, for example, of sexual violence within a command, then the disposition authority ought to be made aware of that. And I'm here to tell you that under a revised system, a revised architecture along the lines of what the Military Justice Improvement Act would provide, that new system would take full account. It should take full account of the views of commanders. Those views, by the way, should be in writing, and they should be provided to the victim or complaining party, perhaps more accurately, and to the accused, so that everybody can be playing with the full deck. Nothing will happen ex parte in this kind of decision-making. To me, there are two other points that need to be made. First, although the conversation today has, not surprisingly and not mistakenly, focused on sexual assault, I think it's critical, senators, that you be aware that the issues you're dealing with are structural issues that transcend sexual assault and sexual criminality within the armed forces. The very problems that I've pointed to in terms of the need for an independent and dispassionate decision maker at the charging stage apply equally to non-sexual assault offenses, of which the Uniform Code of Military Justice's punitive articles have many, many, as you know. So I think it's critical that whatever the committee recommends or reports out should not be limited to sexual assaults. The issue is a structural one, and it should be addressed on a structural basis. Finally, to me, the most interesting challenge that I think the committee faces is not whether to make the transfer, but where to draw the boundary line between those parts of the disciplinary system that are retained by commanders and those parts basically dealing with criminal matters are transferred to lawyer decision makers outside the chain of command. In my view, I think it's quite important that this be kept simple. And to me, the simplest boundary line is the one that we're all familiar with in the civilian community and in the military community. If it's over a year's confinement as the maximum permissible punishment, it should be on the criminal side of the line, handled by lawyers outside the chain of command. And if it's below that point, somewhat arbitrarily, but there it is, it should be dealt with as a disciplinary matter. Thank you very much.
Thank you so much, Professor Fidel. Next, Colonel Christensen, please.
Chairwoman Gillibrand and Ranking Member Tillis, thank you for the opportunity to appear before you today to discuss military sexual assault and the need to reform the military justice system. And Ranking Member Tillis, I would appreciate the opportunity during the questioning and answer period to talk about the question you had earlier about the allies and what their experiences are, and also the data. I agree it gets misstated a lot. I live and sleep and eat this data, and I would love to talk to you about the actual data. 8 years ago, General Raymond Odinero testified before the full Senate Armed Services Committee stating, quote, combating sexual assault and sexual harassment within our ranks is now the Army's #1 priority. Sadly, the recent release of the independent Fort Hood investigative report proved the futility of this promise. Particularly damning was the report's 9th finding that, quote, command climate at Fort Hood has been permissive of sexual harassment and sexual assault. This report, along with the ever-worsening data across all the services, demonstrates how short-lived the Army's commitment was. The estimated number of sexual assaults and rapes of active duty men and women has stubbornly hovered above 20,000 for almost every year that a prevalence survey has been administered. And as Senator Gillibrand pointed out, this does not include the thousands and thousands of civilian victims of military sexual assault. While there has been slight improvement in the prevalence rate for men, this has been more than offset by the increase in prevalence rate for women serving on active duty. In fact, for women, the rate of sexual assault is at its highest level since 2006 and increased by 50% from 2016 to 2018. And while military leadership has failed to make any improvements in the sexual assault rates over the last decade, its record on accountability is abysmal. In fiscal year 14, 4,660 men and women made unrestricted reports of sexual assault or rape. 588, or about 12.4% of those reports, eventually were prosecuted and resulted in 204 non-consensual sex convictions. That's about 6%. And it's important to point out, these are actual sex convictions. The military often inflates the rate of conviction by including charges that are completely unrelated to sex offenses. By fiscal year 19, the number of unrestricted reports had leapt to 5,699, yet prosecutions and convictions plummeted to 363, and again, there was only 138 actual sex offense convictions in fiscal year 19. This is a 50% reduction in both the rate of prosecution and the rate of conviction. So they're taking fewer, not more cases to trial, and they're losing them at a much greater rate. Even as prosecutions have been declining, survivors have been reporting at record rates. But rather than see their offenders held accountable, they are the ones who suffer the price for reporting. And I think this is important to remember the distinction between sexual assault in the military and the civilian world. Retaliation rates for those who report are consistently above 60%, and despite efforts of leadership to play down the severity of the impacts of retaliation, the DODIG report found 1/3 of women who reported a sexual assault were forced out of the military within a year of reporting. A recent RAND report also found that sexual assault and sexual harassment are driving out over 10,000 service members a year. Despite the objective data proving its failure, military leadership continues to vigorously argue that commanders alone are the solution to solving the cancer of sexual assault and harassment. In opposing reform, leadership argues that commanders need more authority, not yet less. Yet I have never heard them explain what additional authority they need that they do not now possess that would drive down prevalence rates or increase accountability. Over the last 30 years, scandal after scandal has been met with promises of zero tolerance and assurance that commanders will eradicate sexual assault from the ranks. The one constant in the ineffective response, we can talk about the 250 pieces of legislation passed, the one constant is the commander-controlled justice system and the abuses of commanders, is the commander-controlled justice system. For most of our history, military justice had a reputation as a brutal and unfair process, and the abuses of commanders were the primary reason for this. Congress, almost always over the objections of military leadership, has continually reined in the power of commanders to provide a less draconian system of justice. Yet as recently as last November, a federal judge warned that military justice was still a rough form of justice. Military justice still possesses many inherently unfair infringements of an accused's rights. The same is fundamentally true for victims of crimes committed by military members. However, while Congress has mostly reined in the evil of improper command influence relative to an accused, the same is not true for crime victims. There is nothing to stop the outsized influence that senior officers and commanders can have on other commanders and convening authorities to stop a favorite subordinate from going to trial by putting their thumbs on the scales. Sexual assault and rape have appropriately put the military justice system under the spotlight. But I, like Professor Fidel, would strongly advocate for professionalizing and modernizing the justice system, even if there was not a single sex offense in the military. After 246 years, it's time for Congress to give the men and women serving our nation a justice system worthy of their sacrifices. I look forward to your questions.
Thank you. Our next speaker is Colonel Lawrence Morris, United States Army retired Chief of Staff and Counselor to the President of Catholic University of America.
Chairman Gillibrand and Ranking Member Tillis, pardon me, I appreciate the opportunity to join your discussion about the most serious matter of sexual assault in the military and the command's ability to continue efforts to prevent and address it. My background is in your materials, so only very briefly. I served 30 years in uniform, 27 of them as a judge advocate, a lot of that time trying cases around the world. Later in my career, I was the chief of the Trial Defense Service, being the chief defense counsel for the Army, chief prosecutor at Guantanamo Bay, and counsel to the superintendent at West Point. After retirement, I was the first head of the Army office whose mission was to train prosecutors and defense counsel in the just and competent trial of sexual assault cases. I understand that sexual offenses have a uniquely harmful impact on our fighting forces and on the families who entrust them to serve in our country. I do not believe that the Military Justice Improvement Act or the main and good faith concerns of its proponents would improve military justice or make for a more disciplined force. Permit me to make 4 quick points, after which I'm happy to answer any questions. First is carefully interpret the data, as to be sure that the data mean what you think they mean. There are so many variables in all of these comparative data sets. It's precarious to compare prosecution rates without sorting for matters like the sanctions available and, most importantly, what constitutes the numerator. A distinctive feature of the military justice and disciplinary system is the ability to reach relatively minor offenses and to try to stamp out precursor conduct committed by those who might commit sexual harassment or other offenses that don't constitute full-scale sexual assault. The civilian sector doesn't have such tools. In addition, it's my experience that the military is much more likely to try the close case. A commander can send a case to trial if he or she thinks it's the right thing to do. I don't think my experience was unique in gaining a commander's approval to try the close cases where conviction was not certain. The October 2020 report of the Defense Advisory Committee on Investigation, Prosecution, and Defense of Sexual Assault validates that experience. It shows that commanders or committing authorities referred close cases to trial, reflecting greater acceptance of risk than is likely to obtain in many civilian jurisdictions where conviction rates can be a manipulable metric. So the military's lower conviction rate, if it is in fact a lower conviction rate, can reflect fidelity to survivors and command seriousness. Second point is if it ain't broke. It once was broke, our system, and that yielded the UCMJ 70 years ago in numerous wise revisions since then. At the core of this system has been the combination of leaders and lawyers. Leaders decide, informed by the counsel of experienced judge advocates. The proposed innovations would not tinker with that system, they would fracture it. It is misleading to claim that commanders make decisions that district attorneys make in the civilian sector. In fact, judge advocates are engaged at every stage of investigation and moving a case toward trial. It's critical to remember that the current system requires the senior lawyer to make 3 specific signed certifications before a commander can refer any case to general court-martial, a profound legal and ethical obligation. Third point, respect due process. The military appellate courts are scrupulous in guarding against unlawful command influence, the creeping of the commander into the courtroom or deliberation room. It has taken generations to arrest this and to maintain the confidence of the rank and file. The courts commonly say there's no such thing as command influence in the air. I'm not so sure. A leader or lawyer who is unduly attuned to pleasing the command might find his judgment distorted in a way that would drive the powerful prosecutorial machinery of the government. Such decisions require the unencumbered judgment of those entrusted to it. So the Senate should think carefully about the impact of legislation like this and the potential for those making disposition decisions to absorb some of that command influence in the air to the detriment of a service member's ability to receive a fair trial. Last point, fully equipped our leaders. If this act were to pass, commanders would be just as responsible for their service members as they are today. They would just have an emptier toolbox. It's paradoxical to leave this responsibility to commanders, but to take away a key element of authority and undermine good order and discipline and military readiness. Even more true in a deployed environment, which the legislation doesn't account for. One of my jobs was serving as the staff judge advocate for the 10th Mountain Division, the most deployed division in the most deployed army in the world. Imagine the complexity of Afghanistan or wherever you might be and meeting the requirements of the bill. Finally, I have a very close relationship with 2 young officers, one of them about to take command of an Army infantry company, another who was recently commissioned as an officer in the Marine Corps, having previously given 5 years of honorable enlisted service. I would like them, as they take charge of soldiers and are entrusted with the care of soldiers, to have all the tools needed to lead their men and women. But my thoughts run more to those who they will lead than to them as the leaders. Those being led need to know that the justice system in the specialized society of the military is an extension of the authority of command. They need to know that the intensity with which a commander invests in their welfare includes underwriting all aspects of a disciplined force under ethical and vigorous leadership. Fragmenting that authority by slicing a considerable portion of discipline to non-commanders undercuts the unity of command and undermines good order and discipline. Thanks.
Thank you all for your testimony. Mr. Morris, you say that you make the comparison that you believe commanders are more likely to press the tight cases than the DAs would. Do you know if the Military Justice Improvement Act has anything to do with civilian DAs?
No, I understand it does not have to do.
Okay, so that testimony therefore would be irrelevant because we are not comparing this to civilian DAs. We are giving this right to military prosecutors who understand the military. Point one. Point two, you say commanders will have less tools in their toolbox. What percentage of commanders have convening authority?
Commanders at all levels rely on the military justice system, Senator Gillibrand. So I recognize part of the intent here is to move the authority previously with commanders for all felony level cases to a sort of a legal command, recognizing that judge advocates touch a case from the point of offense, advising investigators, and then advising commanders at all levels before it reaches.
Let me give you the answer. 3% of commanders have convening authority for felonies and above. 3%. So your testimony is saying that 3% of commanders will have less tools in their toolbox. Does that therefore not say that 97% of commanders will have the same tools they have today?
I don't think so. I think it's not just a matter of referring a case to trial. It's a collaborative and developing impact on the case from when it starts into the system. So in the formal sense, of course, the number of general court-martial convening authorities is appropriately a smallish number. You have developed that general court-martial authority over the course of a career. But the judge advocates, remember, administer and touch the cases all the way through, and they're
We're not talking about the staff judge advocates. In fact, how much criminal experience does an average staff judge advocate have who gives advice to a commander, an 06 or above?
Oh, certainly. I think the great majority will have some amount.
How much? How much? More than a year? More than 2 years? How much criminal justice experience does a typical staff judge advocate have?
Senator, it varies at least by service, but all of them will have some amount.
Some, exactly. And do you think it's appropriate to have the legal advice of a junior, the equivalent of a junior associate on a case that has a conviction penalty of more than a year or above? Because if that's true, then you don't believe in defendants' rights. Because for a junior lawyer with very little experience in criminal justice to be making recommendations to commanders, if you could be thrown in jail for more than a year, is a serious issue of civil liberties. Is it not?
I'm not sure I'm understanding your perception of the system. For a case to go to a...
Do you think a contracts lawyer has the ability to assess a complex case of sexual assault?
I think yes, I do.
I do not. I was a lawyer for 15 years. You develop special abilities as a prosecutor to understand the complexities of these cases. I do not think someone who has expertise in contracts or in HR or in real estate would necessarily have the ability to do that work.
Though, if I could reply, please, we have quite smallish number of people who are involved in real estate law. Most of the people who become staff judge advocates will have been a generalist to a degree. All of them will have tried cases to a degree, but they may then have had expertise in law of war or other areas of military practice that enable them to be the comprehensive legal advisor to commanders who commanders have come to trust.
Do you believe that commanders who do not have a convening authority have the responsibility to maintain good order and discipline?
Of course.
Do they have the responsibility to make sure there's no sexual assault or sexual harassment within their units?
They do, and because that is such a incredibly important part of their leadership, they should then have all of the tools available to them to...
They don't have that authority. You have to be an 06 or above to have convening authority. Do you believe they have to make sure there's no retaliation in their ranks, even if they don't have convening authority?
Of course.
Thank you. I'd now like to ask a question of Mr. Fidel and Colonel Christensen.
Before you do that, Senator, can I make an observation that is quite important in terms of your last, one of the points that you raised with Colonel Morris. The military justice system includes a number of punitive articles that call for capital punishment. And I think this hearing would be incomplete if there were no reference made to that possibility. The notion that a decision to move forward with a potentially capital case, that decision being made by a non-lawyer is, to me, totally indefensible. And I think that should be part of the committee's deliberations.
Thank you, Mr. Fidel. And in fact, most staff judge advocates have no more than 2 years of criminal justice experience. So the commander has no experience, and the lawyer that they have touted as being part of this process all along has very little relevant experience. Correct?
That's true.
Thank you. Colonel Christensen and Mr. Fidel, you've both made the point that commanders' ability to utilize military justice tools under their disposal now would not be significantly impacted by removing charging decisions from the commander to the legal professionals for complex cases. What can we do to ensure that commanders continue to have these tools, or indeed even increase them, so that in cases where prosecutors decline prosecution, the commander still has the ability to take action to ensure the maintenance of good order and discipline? Colonel Christensen.
Yeah, well, we often hear, as Mr. Morris just said, that, well, commanders have all these other tools that they don't have in the civilian world, and that's because unlike any other institution in this country, the employer is also serving as the prosecutor. So of course they do. They have employment decisions they can make. A commander has the inherent ability to administratively discharge someone, to provide them, administer non-judicial punishment, to reprimand them, to counsel them, to give them no contact orders, to put them into pretrial confinement. Nothing that the Military Justice Improvement Act does would do anything to any way diminish those, nor would, as it's been claimed by opposition, nor would it preclude if a prosecutor made the decision not to send someone to a general court, it would not preclude a lower level convening authority to send that case to a special court if the evidence warranted it. That happens right now. A general court martial convening authority can determine they're not going to send a case to a general court. It goes back to the special court martial convening authority, and it can go to a special court. That's a complete red herring from the Department of Defense on that issue.
Thank you. Mr. Fidel, can I ask you to hold your answer so I can give Senator Tillis his turn since I'm over?
Thank you, Madam Chair. Mr. Morris and Mr. Christensen, thank you for your service. Mr. Morris, I want to give you an opportunity. You've heard things discussed today, and instead of asking a direct question, is there anything you've taken note on that you would like to offer up as a counter view?
Maybe just two matters so far. One is the portrait of commanders as these issues are too complex for them. My old friend and colleague, Mr. Fidel, mentioned that, for example, matters of hair analysis or urinalysis would kind of befuddle these lay commanders. It's worth considering an example that might be instructive to a degree on how the campaign to wipe out sexual assault might work. Urinalysis in particular. You know, the military had just an intractable problem with drug use. And in the very early 80s, came up with a credible, efficient, reliable, and defensible in court urinalysis system. I spent a fair amount of time as a defense counsel fighting those cases in that time. And between the public campaign and having a sanction available relatively quickly administered, that problem was reduced to a great degree. So it was not like beyond the head of commanders. We have to understand these are also smart and educated people who are able to deal with a whole lot of complexity in the rest of their jobs. Then the last point, just on the characterization of judge advocates as the equivalents of junior associates. The people who give advice to the 3% of officers who are convening authorities are themselves career lawyers who have managed a lot of complex practice. So it is worth also remembering that, as I mentioned earlier, the lawyers are at the side of the commanders all the way through, and before a commander can send any case to a general court-martial, that staff judge advocate has to certify in writing that there are 3 elements available, including that the evidence is warranted. If he doesn't sign that, commander can't take any case forward on his own.
You mentioned in your opening testimony, I think you referred to the Defense Advisory Committee on Investigation, Prosecution, and Defense of Sexual Assault. I believe at least 2 other commissions, the Response Systems to Adult Sexual Assault Crimes Panel and the Judicial Proceedings Panel. It appears as though in each of those convened commissions with civilian experts that they found no data to support removal from the command. What did they miss? What would you tell me about those studies? But what did they potentially miss that would draw them to that conclusion?
I sat on the Response Systems panel for the year and a half or so that it was in effect, and I was like at the kids' table intellectually with all the other people who served on it, but it was a really impressive, open-minded analysis of the system, and included a range of people, including some, career-long, strong, informed critics of the system. And at the end of that examination, all of them came to I think virtually all of them came to the same conclusion of the appropriateness of the convening authority structure.
Are you familiar with the other panels and their conclusions?
Of the conclusions, I am. I mean, not intimately, but same. I don't think there was any significant difference.
Thank you, Mr. Christensen. And I am a data analytics person myself, and what I'm really trying to sort through here are foundational aspects of this challenge. Number one, if we pass any additional congressional measures, that we're able to make sure that we've gotten it right, and we have to do that through tracking. But we also have to get what I referred to in my opening comments, what I see as competing data. So I don't have time, or we don't have time to go through that right now, because could argue that maybe you give me one view of it that needs to be matched up against the other view and normalized. But I would appreciate either the opportunity for me or my staff to speak with you and get information so that we can really get that baseline, so we have well-informed decisions as we consider not only the need to move forward, but how we could actually measure it if we do move forward with anything.
Absolutely. I'd love to do that. Like I said, I sleep and breathe this data. It's what I do almost every day, looking through the data. So I'd be happy to do that.
Thank you very much. Thank you all for being here, and thank you, Madam Chair.
Thank you. Senator Warren on WebEx.
Thank you very much, Madam Chair. So in 2013, my first year in the Senate, this committee considered competing ideas to tackle the problem of military sexual assault. Senator Gillibrand's Military Justice Improvement Act would have put the decision to prosecute sexual assault cases, along with the authority to convene a court-martial, outside the accused's chain of command. Unfortunately, Senator Gillibrand's proposal was not included in the Defense Authorization Bill that year. An alternative series of proposals that proponents argued would be more effective were adopted instead that year. And that alternative approach included several important items, including requiring commanders' performance evaluations to include evidence of their compliance with annual command climate assessments of their handling of sexual assault cases. And I remember many folks saying that's what's going to get the job done. So let me ask, Colonel Christensen, since 2013, since we put those rules in place, has the sexual assault problem in the military gotten better, gotten worse, or stayed about the same?
It's gotten worse, significantly.
All right. So 1 year after those reforms were adopted, in 2014, this committee went a small step further and required that commanders' performance appraisals include whether they had established a climate of properly managing and fairly evaluating sexual assault. People told us this is going to get the job done. Colonel Christensen, are you aware of any commander who has been relieved or not promoted based on that criterion?
No, I would say the only kind of exception to that is the Fort Hood report resulted in people being fired, but it wasn't because of a climate survey. It was because they ignored their climate surveys and all the other issues there.
So in fact, it's interesting you'd raise Fort Hood. Fort Hood is kind of what proves the point here, isn't it? The Fort Hood Independent Review Commission, which looked at this issue, found, and I quote, a permissive environment for sexual assault and sexual harassment, suggesting that this was not getting in the way of anyone's career advancement up to that point. So is it fair to say that we have no idea if commanders are really being held accountable in any way whatsoever for their handling of sexual assault in units under their command?
Yeah, I know of no publicly available data that shows this. The Privacy Act often is used by the Department of Defense to shield anyone who would have been fired. But we do know that there are problems within units like Fort Hood that were long and systemic, that commander after commander knew about. Senior commanders knew about it, yet nothing was done.
So let me just ask you plainly then, Colonel Christensen, have we gone far enough when it comes to holding commanders accountable for sexual assault?
Absolutely not. But one of the problems we have is because we have a commander-controlled justice system, it's very difficult to find where the line is to hold them accountable, because then it crosses into unlawful command influence. That's one of the reasons it'd be much better if we took prosecution authority out of their hands, because then you could more easily hold people accountable.
It's a very interesting point. You know, military leaders to a person have come before this committee since 2013 saying we cannot take commanders out of the chain of command over sexual assault cases. Commanders are the only way that we can solve this problem, and we will fix it. They said that, and yet here we are 8 years later and thousands of sexual assaults later. And not only have commanders not fixed anything, but the problem has actually gotten worse. And we don't even know if the people we're relying on to address sexual assault are being held accountable or are incentivized to care about this scourge in their ranks. Military commanders have had their chance. They said they would fix this, and they didn't. It is long past time for this committee and for the Congress to do the right thing and pass Senator Gillibrand's proposal. I'm going to fight alongside her until we get this done. Thank you, Madam Chair.
Thank you, Senator Warren. We're going to take a quick second round, if that's okay with you, Senator Tillis. So we've had a lot of discussion about the sacred convening authority, and I want to get back to the issue of the fact that most commanders do not have convening authority and never will, since it is reserved to 06 and above. Colonel Christensen, is it possible for the 97% of commanders to maintain good order and discipline and to keep control of their troops and have good command control without convening authority?
Absolutely. It happens every day. For example, in the Air Force, the commander that has the most immediate impact on the good order and discipline of a unit is the squadron commander. Squadron commander can use administrative punishments, can use counselings, but they cannot prosecute someone. They can charge someone, but literally anybody can charge somebody under the Uniform Code of Military Justice. But they don't have the ability to send someone to court. All they have to do is the ability to say to a superior, please prosecute this person. That would be no different under the Military Justice Improvement Act. There's nothing in that act would prohibit that squadron commander from trying to convince a prosecutor, just as they have to try to convince a convening authority that this case should be prosecuted.
Thank you. And Mr. Morris went on and on about the multiple panels that have looked in this. And that's true. There's been multiple panels. There's binders and binders and binders of recommendations. Every recommendation that's been made that is a legitimate legal change that Congress can take up, we've actually made. I've made sure we made it. And so I want to answer the question he asked, that Senator Tillis asked. Why did they not make this recommendation? Colonel Christensen, you might have some experience in that. Why did they never make a recommendation to look at the Military Justice Improvement Act as a solution, to your knowledge?
Okay, well, so first off, only the Response System Panel looked at the role of command. The Judicial Proceedings Panel was prohibited from looking at the role of command, and the DAC IPAD has not looked at the role of command, whether or not they should be in charge. The Response System Panel voted 7-2 to retain command or convening authorities. What's really important about the Response System Panel, there was a lot of qualified people on it, but the Department of Defense overwhelmingly controlled who testified before the Response System Panel. And no surprise, those people who testified before the Response System Panel, and I did myself, were there to support the chain of command, or the convening authority system. If you look at the number of witnesses they talked to who were experts on prosecutions or had a contrary view who wore the uniform, it's minimal because they weren't allowed to speak. Also, the Military Justice Improvement Act, as far as I know, wasn't even proposed at the time the RSP met. But I think it's really important to understand what the limitations are. Even with the DAC IPAD, where they looked at and said that, well, we believe commanders made a reasonable decision in 97% of the cases or 95% of the cases, you have to understand what they were doing. They looked at the investigative files from investigative agencies such as CID, OSI, or NCIS. They looked at 1,700 files where they spent about an hour per file to make a decision. They never talked to any witnesses. They didn't know what the lawyers in that case involved or looked at. And those investigative files, as it's put into the DAC IPAD report, were incomplete and did not contain everything they needed to be making a fair assessment. So I would not take away too much out of this idea that DAC IPAD looked at that. I'll give you an example. I would never recommend whether a case go forward or not, reading a report of investigation for an hour without ever talking to a single witness and, most importantly, the victim. You should really take that with a grain of salt.
Thank you. Colonel Christensen, also another statement by Mr. Morris was that, God forbid this happens in Afghanistan. You couldn't possibly deal with this system. Can you please explain what would happen if there's a rape in Afghanistan, Iraq, Virginia, anywhere in the United States or in the world?
Well, let me give you an example. So for the Air Force assets, most of them are deployed in Iraq, Afghanistan, Qatar, Kuwait. The convening authority for them is the CENTAF commander who's located in Shaw Air Force Base, South Carolina. So it would be nothing different if the prosecutor making the decision was not there. But there's absolutely no reason why there cannot be multiple career prosecutors making these decisions, and there's absolutely no reason why you could not forward deploy one of those prosecutors to deal with this. You have to understand, we talk about how, well, this is in Iraq or Afghanistan. Well, in order to court-martial somebody in Iraq or Afghanistan, you have to have defense counsel, prosecutors, court reporters, and judges. It would be nothing different to bring in a career prosecutor to make the decision. So that, again, is a red herring situation. And then the last thing I would say on that, Senator, is that the vast majority of serious crimes that were committed in Afghanistan or Iraq that would be covered by MJIA were brought back to the United States and prosecuted.
And last, Mr. Fidel, you recommended that this Military Justice Improvement Act be applied to all serious crimes, the equivalent of felonies, and you stated that you were in favor of a bright line. Have you looked at our bill, and do we provide that bright line?
Is this on? Yes, Senator, you've provided a bright line, but I've got a brighter one. I think the anything over a year avoids the kind of anomalies that show up. I mean, I've looked at this 8 ways from Sunday to try to figure out if there's a truly nourishing, satisfying way to draw the line. The answer is there isn't. Every possible array, you can always point to something and say, I think that should be on the other side of the line, and that thing over there, that should be on this side of the line. I think the simplest way of doing it really is the familiar felony misdemeanor dichotomy. The military justice system, by the way, doesn't use that language, but as a practical matter, every American knows what we're talking about when you're distinguishing between felonies and misdemeanors. So that's the best I can do on that subject. I would say this, by the way, Colonel Christensen, and I might add, Senator Tillis, you may not be aware, but I also served in the military when I was a younger man. The response systems panel, as Colonel Christensen mentioned, had a dissent. And sometimes a short document, there can be a great deal of wisdom in even a short document. And I strongly encourage that every member of the committee read the dissent that was prepared by Professor Elizabeth Hillman, who is now president of Mills College in the Bay Area, and the state prosecutor in Virginia Beach, Virginia. It's a brilliant account, and I think it's an unanswerable case for why commanders should not have the kind of authority that we've traditionally given them.
Thank you. Senator Tillis?
Mr. Fidel, thank you for your service, too. Actually, the one follow-up question I had for you was related to that line. I think in your opening comment, you were saying anything that would result in a year or more of...
that could result.
That could result in a year or more.
No, more than a year.
More than a year, yeah. And Mr. Morris, just back on the follow-up question that Chair Gillibrand had with respect to the complexities of a forward deployed situation, why would you disagree with what Mr. Christensen said? You alluded to it being difficult or complex. Mr. Christensen said it's not really that much different. Did I just infer from your comment or the follow-up question a difference of opinion there?
Yes, and I know his perspective is that a fair number of cases were returned from theater to be tried in the States, which had not been my experience. But it is just, I don't think that complexity is accounted for in the legislation.
Thank you. Thank you, gentlemen, for testifying today.
Just to clarify, Mr. Morris, where is the convening authority typically for a unit that is deployed?
Typically forward with the unit.
Mr. Christensen, Colonel Christensen?
Well, it depends on the service.
Okay.
So for the Army, their convening authority, Marine Corps, their convening authority was there. For the Navy, who knows, because the Navy ships are moving around. For the Air Force, it's Shaw Air Force Base, CENTAF. For general court martials, there were special court martial convening authorities there, but for felony level cases, for almost every deployed airman, it was at CENTAF. And I would just add, we can look at Bale, Sergeant Bale, the guy who went into the Afghani village and slaughtered, I think it was 14 Afghani villagers. He was prosecuted in Washington State. The people who at Abu Ghraib, who were abusing the prisoners, were not prosecuted in Iraq. They were prosecuted in the United States. There are a lot of summary courts that occur in theater, but summary courts would not be touched by the Military Justice Improvement Act. And the vast majority of cases, I mean, I had personally prosecuted cases in theater. but those were simple cases. The one rape case I was doing in theater got transferred to North Carolina.
Thank you. Go ahead, Mr. Fidel.
There's another source. You've heard about a variety of reports. Let me simply mention another one for your idle hours. The Defense Legal Policy Board, which existed under a prior administration, did a report on effectively war crimes. I'm having trouble remembering the exact title, but part of that subcommittee report addressed the question of where offenses were being tried. That is, offenses committed in a deployed operation, but some were tried in country and some were tried back here in the United States.
Thank you very much. Senator Tillis, any further questions? Gentlemen, thank you so much for your testimony today. This has been extremely useful. There may well be follow-up questions that I will submit to each of you to respond in writing to give to the full committee. There are many other senators on this committee who I think would like to hear your testimony, so we will make that available to them. So I'd be grateful if you would submit responses for follow-up questions in writing. Thank you very much. Take care.
Thank you.
That is the end of our hearing. Thank you for all the participants. Adjourned.